Hi.
And some sort of generalized anti-cracking activity, but this sort of heated it up, and so eventually, a couple weeks ago, as many of you know, we started Don't Frack in Michigan. However, James Olson, who is an award-winning and longtime environmental lawyer from the Traverse City area, is just basically going to be presenting fairly neutral information about what, well, let's see, legal strategies and tools. So he's probably going to speak for about 45 minutes, and he will then take questions and answers. So let's welcome him.
Okay.
Still over here, hiding out. Okay, thank you. Did everybody get a packet?
Not everybody.
And that's another thing too. Sign in
There are
if
packets over
there
here.
is a sign-in sheet.
I'm going to be referring to these. In fact, I'm going to grab one myself. Well, thank you, Susie, and thanks for sponsoring this and all of those that worked on this meeting, and for coming out to this meeting this evening. First of all, I want to just talk a little bit about flow. Flow was started in 2008, right after the Nestle water case ended, and shortly before, well, after the Great Lakes Compact, which of course has the diversion ban, preventing water from diversions outside the Great Lakes Basin, was signed by the governors, and shortly before it was approved by Congress. Myself and Terry Swear, who was the president of Michigan Citizens for Water Conservation, that led the fight in court case against Nestle, which took 9 years, and which ended up in a final judgment being entered limiting the extraction of the water and the piping down to the Stanwood plant from Acosta to about an average of 125 gallons per minute in the summer. They had actually wanted to do 400 gallons per minute, and actually originally it was about 600. And about an average of 200 gallons per minute or 215 gallons per minute in months of the year where there is more precipitation, thus minimizing the effects on lakes and streams and groundwater in springs and wetlands. What was clear from the ending of that case and the ending or the new chapter of the existence of the Great Lakes Compact was that even though we were making good headway, and those were milestones in public cooperation on the one hand and definitive water law litigation on the other, and decisions being made by the courts, there were two things that were quite troublesome. One was, in the compact, there's a diversion ban or definition of diversion that has an exception for products, and the definition of product includes, quote, water intended for intermediate or end-use consumers, close quote. Well, that's an export. And that's not the bottled water export. That has no limitation in it, in that definition. So that weakness, coupled with the change in Michigan water law, how many people live on a lake or a stream in the room here? Okay. How about any farmers that use groundwater, or gardeners that use your groundwater? Yeah. These uses of water in Michigan up until the Court of Appeals case in Nestle allowed people to use water freely, reasonably, and not injuring your neighbor, in a watershed, or those sharing the same groundwater. And if somebody tried to package it and sell it somewhere else, our law under Michigan Supreme Court decisions prohibits it if it diminishes the flow of a stream, the level of a stream, or a wetland, or a swamp, or a spring, in any material that is measurable way. So we have this sense that you can move water out of a watershed, but you can't affect the quantity of water in the watershed overall during a given season or year. That's a pretty amazing protection, because that means under our common law, no matter if we have a Great Lakes Compact or whatever kind of law we actually have some fundamental protections against outside interests that under international trade laws could come in and buy large quantities of land and export the water out of here to meet needs of the world water crisis. Or, for example, we're going to talk about fracking. The battle in the West, we have a significant water issue here in Michigan. The battle in the West is not between water and the environment or nearby neighbors. The battle in the West is between energy development, oil, and farming. In 2011, spring of 2011, the oil industry outbid the farming industry, the farmers on the eastern slope of Colorado, for the extra water from the snowpack. And so those farmers, they still had some of their water rights, but they suffered significantly that year. So that's the kind of thing that Flo was interested in when we started. Now what we're about is looking at all of the threats to the Great Lakes and looking at this is kind of a funny thing. I can't click. You have to roll it in order to do this. So I hope you don't get too dizzy. I feel like I'm anyway, going back and forth in a car, trying to get out of a snowdrift or something. So anyway, what we're trying to do is create a new framework for this century, for all of us in the Great Lakes Basin, that looks at the Great Lakes as a commons in order to, I don't know why this thing does this. In order to address issues like the water piece of fracking, mining, lowering water levels from over-dredging out of Lake St. Clair affecting Lake Michigan, the Chicago diversion, wetland loss, the relationship of climate change and global warming from greenhouse gases, trying to pin down the science of that and what might happen to the Great Lakes. Looks like we've lost about 10 or 12 inches currently, largely because the scientists are graphing or tracking and plotting the precipitation, which stays fairly normal, within a normal range, but the evaporation is increasing rapidly because of the lack of ice cover and increasing in warming, and therefore dropping the water levels of the Great Lakes. So what we're really seeing in Lake Michigan now is a combination of climate change and the historical diversions and the dredging. So what we're trying to do at Flow is take all these threats and ask ourselves, is there some fundamental principle, in addition to all the other things we do in our daily lives and all the regulations, by which we can go into this century and educate each other so that there are outer limits on what others can do to the Great Lakes Basin through climate change, exports, China buying land in the United States or in Canada and using the abundant water resources to grow their crops and send them to China so they can use their water resources in the south to mine the coal in the north. That's what's going on in China. They don't have enough water to grow their food, so they're moving around the world and buying land in Brazil and Africa and elsewhere, wherever they can. That's the general trend because of the world water crisis. What we want to do in the Great Lakes Basin is develop a principle, and fortunately we don't have to develop it because there's an ancient principle called the commons that is, water has been recognized and air have been recognized legally as a commons, meaning they're not owned by anybody and they're managed by government, the sovereign, for the people, for their good and benefit, okay, in each country. And obviously there are no political boundaries when it comes to air and water for many reasons. So it's also significant in terms of not only a watershed level principle, but a Great Lakes region principle, and then between regions as we move into this century. But The commons come to us from English common law, just like private property comes down to us. Okay? And your rights of private property and ownership include the right to use water, but you don't own the water. Contrary to reports in the 2010 election in Michigan, there is no ownership of groundwater. If anybody owns it, the state does, but they don't own the title. They own the sovereign interest, which really means they have a duty to protect it for all citizens. That's the law. It has been for about 2,000 years, from Roman civil law to English civil law to U.S. law and Canadian law. That's the principle. And the basic use rights you have in connected with property, or being a member of a community who is served by a water, a municipal water service, or a private one if you're in a subdivision or something. They own property and develop it and pool the water and service you with that water. So it comes down in that way, and it's shared based on this idea of correlative rights, which is reasonableness. Private people share it on a lake or a stream. The public shares it on a lake where there's public access. The public gets to use it for fishing and boating, and the private landowners get to use it for that, and they also get to use it for growing crops and gardens and other things in connection with their land, which the public doesn't get to do. Okay, so on top of the commons is what's called the public trust doctrine. The public trust doctrine is a principle mostly, well, it also comes from English common law. The Crown of England could never subordinate the citizens' right to navigation, travel, and movement, because they needed to get in boats to go fish, or fishing, or shelling. Why? Because that was a basic way to get food. And so the seabeds could never be subordinated and taken from the public. The public use was paramount. And the Crown tried to do that at one point by cutting a deal. England was, broke from spending too much money in Europe, in various campaigns, wars. So the Crown went to the Lords, the big barons basically, and said, look, I need money. And the Lord said, give us the seabeds and you can have the money. And the Crown did that. And there was a revolt in England, and it established this public trust principle, recognized by the courts of England, adopted by all state courts in the United States. Many decisions here in Michigan recognize it, and the U.S. Supreme Court. And so each state, when they joined the Union, took title to the water, the moving water, and particularly the navigable water. In Michigan, it's wherever you can float a 10-foot log. That's public trust. The water is, as I said, a commons, but it begins to be public trust at the point you can float a 10-foot log. Well, you can imagine that the water moving from groundwater into the stream up to the point of the stream where it's 10 feet is all one body of water. So the public trust says the government has to protect the water, and no one, not any other person or a private person, can substantially impair the quantity or the quality of public trust waters, like the Great Lakes or the Rogue River or the Muskegon River, right on up to the headwaters of those streams. So we think that the concept and principle of commons at flow and the principles of the public trust doctrine create an umbrella that can protect the Great Lakes for this century. And if we do it right, we can have robust economies, good quality of life, all right, good business, good farming, good tourism, and truly have a pure Michigan if we follow these principles. And, that's not my talk this evening, but I wanted you to know about flow because it's the backdrop of the very reason I'm here. Because we have 4 programs right now. One is this Great Lakes Public Trust Principle, educating the public. We do seminars like this and write articles about this, so everybody is on the same page about this, and we get it when threats come this century. The other thing we're looking at is the water level issue and how the public trust principles should be used to ratchet back things that affect water levels, because the government doesn't have a right to interfere with boating, swimming, fishing, recreation, tourism, use of water in connection with your riparian land or lake. Okay? So we think that's a really important proposition. And then we're also working on a new program for colleges in Michigan, and we hope beyond, in the Great Lakes Basin, which begins to look at water as a water cycle, not as just one little piece of water under your land or a lake or a pond, that we understand that it is all one. That's pretty basic, but it's amazing how the law has forgotten that. And so what we want to do is begin to understand this cycle, and that where things affect the cycle, wherever it is, whether it's the removal and loss of water from the cycle from fracking, which we're talking about this evening, or climate change to the atmosphere, which is affecting the water in the vapor state here, okay, and affecting what happens when it comes down here, or removing too much groundwater before it reaches the surface water, where it's a navigable stream or a lake, which is protected by the public trust. It's all one. Everybody is upstream. Actually, with the cycle, everybody is upstream and downstream. And it's happening everywhere on the planet all at once, simultaneously. I don't know how else to say it. So it's not like, oh, where you're standing, there's this little water cycle going around. But it is all part of the system that interacts with and actually creates the life on the planet. And so at Flow, we want to start an entire education for a new generation centered on a water policy centered on this cycle, both in science and in principle, including the idea that it's a commons, because if this water is a commons and all of this is part of it, how could it not be? And who's going to own the clouds anyway? I mean, I know we try. With silver nitrates, we try to lasso the clouds, and there's always somebody battling. I see a law review article every once in a while about somebody wanting to chop off or get one of those big icebergs that drops off of Greenland and haul it down to Galveston.
Geoengineering.
So there's always that struggle, but it belongs to everybody. It's part of this commons. Okay, so now we get to the business of the evening. First thing I want to do is just real quick, I talked about the Great Lakes Compact. I talked about riparian groundwater law. I don't want to spend a lot more time on this. Michigan passed the 2008 water law to fill in the gap. When the Great Lakes Compact was signed, Michigan had to not only address diversions, every state had to adopt a diversion ban when they agreed to the compact, but they also committed themselves to regulating consumptive uses. Uses where water sometimes doesn't come back. And so they've regulated high capacity, high water uses, not existing, but new or increased water uses, and you need to get approval from the state. There's two ways to get it. One is you have to go through the water assessment tool. There's a tool, and it measures what's called adverse resource impact, ARI. ARI means that whether you like this or not, it's not perfect. It's got some weaknesses. The ARI means that depending on whether it's a cold stream, there's no adverse resource impact until you've dropped the water enough to kill 2% or 5% of the characteristic fish population. Fish are public trust, by the way. So we actually have a water policy that allows wiping out 2 to 5% of our fish population in our cold water streams. I'm not sure that's a good policy, but that's what it is. A little bit relaxed. Then in the cooler streams, it's higher, 5 to 10%. And then the warm streams, higher yet. And then if it's a big warm stream, you can take out up to the backstop number of 25% of the flow of a stream. Which seems insane that you could say that the larger parts of Muskegon River, you could take up to 25% of the flow of the Muskegon River. I'm not sure what the state will do if that ever happens. I doubt that one will happen, but it's not a very good backstop standard. The other thing about it is this water assessment tool, if you comply, if the computer says it's information in the computer, you print your property location, your name, how much you're going to use, when you're going to use it, how long you're going to use it, what kind of well it is, how many wells, and you total up all those numbers of gallons, what you're going to take, you plug it into the computer, and the computer says whether or not you're going to have an adverse resource impact. If it doesn't flag an adverse resource impact, the computer in your office, on your desk, prints you out a receipt that says you can do whatever you want with this proposal. They have a copy, you have a copy. Now, we tried that with the Nestle case to test the tool, so we put all the numbers in, used the location in our office. Jeff Jocks did this, and the Nestle case passed the tool. Even though it dropped the flow 18 to 35% based on the factual findings of 19 days of cross-examination of expert witnesses in science, you couldn't have had it done more carefully. And so the tool is a guide, but it doesn't work very well in terms of getting down to the real questions. So I'm telling you this because I want you to have this backdrop, which I'll end in a minute. We'll get onto the fracking regulation issue, but I'm telling you this because local governments and communities largely are left to themselves these days with a lot of things. Budgets and trying to serve your people. If you're on how many local government folks here? Any of you here? Yeah, I mean, you know how much has been put on your backs. It's pretty tough. And when it comes to a lot of these regulations, the same thing is happening. And so I'm giving you this background because it's pretty much up to local governments to deal with water issues on the larger and the specific scale, both to make sure your community doesn't end up somewhere where you weren't planning to have it end up. Okay? So that's just a few things. The last thing about the water law is the reason they're having problems is the state doesn't have enough money to get all the stream flow data everywhere where these wells are proposed, whether it's a fracking well or a city well or a big irrigation well or whatever, manufacturing well, these high capacity wells. You can't, there's some USGS, USGS means United States Geological Survey. They do a lot of the water soil studies and a lot of other things for us in this country. And they're a really very, very high-class outfit, I think. And they do what they can. The stream gauges in Michigan are all downstream in the big rivers. Like the Manistee River, the gauge is, the Au Sable, it's down below Grayling. There's a lot of Au Sable River above Grayling. And likewise, there's another one further down. And the Muskegon and all the big rivers have gauges. There aren't any measurements or gauges in the creeks and the tributaries and upstream of these gauges. So how do we know the flow? How does the computer know the flow? The computer does this. It's simple mathematics. If the flow at the gauge is 10,000 gallons per minute, let's say, and the square miles of the watershed of that river basin above the gauge is 1,000 square miles, okay, then that's the ratio. So if you go upstream and there's a big fracking well going next to a stream or a wetlands and springs that feed a stream, you figure out the square footage, or excuse me, the number of square miles above that point in that same watershed. It's a smaller, the big circle from the gauge, the gauge, there is no gauge here, but there's a point, the little circle. And so if that's 100 square miles, then the flow of that stream is 1,000 gallons per minute, even though if you went and measured it, it might be 10 gallons per minute. So the tool is an estimate, and it overstates flow in most instances, not all, but tends to overstate it. And because it overstates it, what does that mean? If you overstate the amount of water, and when you ask for an adverse resource impact determination, what's that do to the analysis? Well, if you overstate flow, you understate impacts because there's more water. Okay? So that's the basic structure. So, given that, talk some real quick things here. I don't want to spend a lot of time, and I also wanted to say, one of those projects is this fracking, as you can tell. That's our fourth program. I don't even know if I said that. I apologize. That's why we're here. And that's the information that you have. And we have a white paper. If you want to see it, it's on our webpage. If you have trouble getting it, call the office. But it's a more in-depth legal analysis of your rights as local governments to what you can and cannot do with regard to fracking. The reason we did this program is that we felt a year and a half ago when we started thinking about this, and then I had 2 interns last summer, just terrific interns, and we all thought, you know, nobody's helping the local governments understand and the public really know what's going on, and the state regulations are fairly weak, and the feds are doing practically nothing. So this is something that's really needed. And because our focus at Flow is water, because the water is connected to so many things, particularly in local communities, we thought this is a mission for us. And we've gotten some funding for it. We need lots more. We're doing 3 townships right now. One of them is Cannon Township. Another one is Gunplain in Muskegon County. And we're looking for a 3rd local government community to work with. We offer 3 sessions to work you through this, identifying what it is you want to address and what ordinance package you need to address fracking before it happens in your community. Okay, address the land use issues that are involved with that, or the nuisance or threats that might exist so that they don't happen. And if they do happen, you have indemnity and all that kind of stuff. So that's what the mission is about. And if that works, our hope is it will spread, and then we also hope with citizens' help that we can continue to get funding and do this. We match, each township pays $2,500 for that whole 3-month session, and we go out and get the other $2,500, and it's capped at $5,000. That is a deal, I can tell you. I mean, being a lawyer and knowing how much it costs to pay a planner and a lawyer, that's a good deal. And we want it to be a good deal, because we think it's important. Okay, so the basics of the you will hear that fracking has been going on for 60 years in Michigan, all right? And yes, there's been some fracking. Somebody put some chemicals in the water or some sand and blew it down in a hole and tried to get more gas or oil out of one of those Niagara oil and gas wells. Okay, it was a vertical well. Then the Antrim Shale development came along in northern Michigan and down into Manistee in the mid-1990s, right? And right on up until the 2000 or so. Those are fracking wells. They use chemicals and sand mixtures, but they're vertical wells a half a mile down within an 80-acre unit, okay? And they frack the Antrim Shale, which is more friable than the dense stuff that we're talking about with the deeper stuff. And it breaks it, and they increase the amount of gas or oil that they can recover, mostly gas. Okay? 0.5 miles versus the deep fracking 2 miles down. Now, it might be a little less than that, it might be a little more than that, because as you know, Michigan's this circular under the Lower Peninsula, the geology map. If you look at the book, there's this many layers of rock formations. In the middle, somebody punched it with a fist and made a bowl, like a potter. And so those formations are not always at the same distance from the level. The more you go out to the edge, the closer you are to the surface. But even up in northern Michigan, where you get closer to the surface, they're 2 miles down, the Collingwood and Utica Shale. In this area, there's another formation just above called a carbonate. We don't know for sure which formation will occur here, but it looks like a carbonate that's what it appears to be in that the companies are after in the well that's being considered in Cannon as well as Allegan County. Okay, that's what it looks like. That's my guess, and it's not a real educated guess because a lot of this information is not available until they actually apply for the permit. When the companies lease the state land, particularly all your precious game and recreation areas down here, they don't have to say it. They don't have to tell you anything. The state just lets them lease it. We don't know how much water is going. We don't know what the impacts to our recreation state parks are going to be. That's a whole other issue that we have to address. And it's an issue that you can address somewhat at the local level. So, water use, boy, I'm sorry. I don't know why. There we go. So the water use with Antrim was anywhere from 10,000 gallons up to 50. On average, it's 10 to 20. Okay? Deep fracking, down 2 miles, and generally, that's just the start. Generally, it comes over 2 miles. It could be more, it could be less, depending on what they find in the formation. All right? And this uses up to 30 million gallons. Actually, the first fracked wells in Kalkaska County used 42 million gallons of water. Now, you've been told by the DEQ that it's about 5 million. They're now admitting that it's at least 21 million.
Isn't there one that uses...
Okay, so now we're up to 21, 20, 30 million gallons per well, per frac, and some wells are fracked 2 or 3 times. Okay, on top of that, in your packet, if you would pull out something called a frac sheet that's got the same, somewhat similar graph on it, only a little fancier with the big bubble of water there. You'll see at the bottom, and I'm sorry it's so small, that's the frac pad. And the frac pad is where all the equipment goes and all the wells go. And there is a big 1 million gallon water tank, and then there's a big chemical tank, chemical storage area, and there's a big mixing tank, and then there are high pressure pumps, and then there are water wells to pull water from the groundwater, multiple wells, and then they're talking about putting more than 1 well on each pad, and in fact they're now looking at 5 wells on 1 pad in Kalkaska, and 1 pad next to it with another 5 wells, and potentially 13 wells in 1 area when they get done. So let's just look at the math at that a minute. It could be that if you have 5 wells on 1 pad area, 5 to 10 acres, you'd have to multiply that times 5. If you got 10 of them, you're up at 300 million gallons in about a 2-year period in order to complete all that fracking. If you take 21 million gallons, fracking takes about 3 weeks. And we've talked with the DEQ and the people that are doing this, and we know that to be a fact. It's about 20 to 21 days. Unless they have problems and they have to come back and refrac and remix and add more water. So this quantity of water at 21 million gallons per frac, let's say, and I'm using this because of the easy math. It makes it easier for me, hopefully for you too. In 21 days is 1 million gallons a day. Okay? If these are in rural areas near creeks and streams and wetlands and groundwater used for other purposes like what streams are used for, or farming, for example, during crucial periods of the year, like summer months, for example, if you withdraw this amount of water out and the farmer needs 1 million, there's going to be a huge competition between the irrigation needs and the fracking needs, and you need to be aware of this. Here's now, let me give you the comparison to the Nestle facts. In Nestle, it was a permit to go 400 gallons per minute. The state issued it. The court heard all the evidence, and the final judgment was 125 gallons a minute during the low flow period. The dead stream is about 2,000 on average, about 1 to 2,000 gallons per minute of flow in the summer for about a half a mile down from where the wells are and on down into the Tri Lakes, if you're familiar with that area of Big Rapids. Not unlike some of the areas around here. Very, very resource, wildlife rich because of the water. So if 400 gallons is not legal, and if 200 gallons per minute will drop a stream by 1 or 2 inches within, let's say, a half a mile of those wells, and if it drops to groundwater, it's called the zone of depression, cone of depression, excuse me. That's not a metaphor. It's a literal depression, and it can extend out to one half to, at 400 gallons per minute, it can extend out to a half mile and drop the water level 2 to 6 inches, the groundwater table. If that's a wetland, that wetland drops, because the wetland is just groundwater showing on the Earth's surface. Okay, and then that changes the plant makeup, the habitat, and the wildlife makeup. That's just one example. So this is pretty significant stuff in terms of numbers. If you're talking 1 million gallons a day, I was just talking about something less than that, 400,000 gallons. If you're talking 1 million, you can start to double and triple some of those effects, depending on the soils and the clays and rocks and the formations, which requires a hydrogeologic study. You got to look at the soils, you got to measure the stream flows, you got to look at the groundwater, how much can it absorb, how much is there, up gradient being captured in the watershed before it gets to the point of the well, right? Based on snow melt and rainfall. You have to know those numbers. We're not knowing the numbers before we're issuing water permits in the state of Michigan. We don't know those numbers, and we don't require the oil and gas industry to supply those numbers before they get their permits. So local governments are kind of left, and citizens, you're kind of left to fend for yourselves in many ways. I don't want to say that there's no protection, because the state is looking at it with the tool, and if it doesn't pass the tool, the companies get to, they're not bound by the tool if they don't like it legally, but they're following it because the supervisor of wells issued a letter directing them to. But they don't have to follow all the requirements. They don't need a permit if they don't pass the tool from the state. They just have to satisfy the department before they issue the oil and gas permit that there's not going to be any adverse resource impact, however they decide it. But the Water Bureau people that normally decide that are not deciding it. They're helping decide it, but ultimately the supervisor of wells issues the permit. So it's kind of a confused, subjective, when you get down underneath everything, it's quite subjective without solid information and solid standards that we all know and play. When you have a game of sports, or you're trying to have a community where you're all sharing, it's a pretty good idea to know what the principles are. So everybody has what? Fairness. It's called due process in our Constitution, and we're all treated equally. It's called equal protection. And it's just basic civility and democracy. So, I'm going to go past this in light of the hour, but this is just the information of how much acres have been leased, and this was just up until earlier this year, before the spring auction, which was another 40,000 acres or so. So up to about 800,000, a little less than 800,000 acres have been leased to state lands. Significant portion below M55 being all the special areas in your area, the game and wildlife management areas, which you all know about, the trails. That's all federal and state money spent for conservation with tax dollars designated for conservation use and purposes. And the state says those areas are held in public trust on all their rules and procedures. And I'm not sure they're applying that public trust principle we talked about. That's to be determined in the future. The acreage price, you can see where that's been going. The last auction was a minimum bid price of $10 an acre. So not a lot. Why aren't we holding it until it's worth 100 or 200 is a land policy? Okay.
Why aren't we?
Well, here are some of the risk. Frisk or fracking risk, a new word, a word blend for you writers. So massive water consumptive use. Consumptive use means it's gone. Chemical mixing. The chemical mixtures are about 29. There are 29 chemicals identified as carcinogens. The list changes depending on what you read. I'm just trying to stay somewhat in the middle here. So 5%, excuse me, 1/2 of 1% of that 30 million is the chemical sand mixture. And you'll be told time and again, the chemical is only 1/2 of 1%. It's all water. Don't worry about it. Well, when they bring it on site, before they mix it, if you do the math, you're talking about 300,000 and 400,000 and 500,000 gallons, if we use gallons as the measuring device container as opposed to pounds. That's a lot of chemicals. And we all know that parts per million and parts per billion are the standards for water and groundwater in Michigan. It's very small percentages. So I don't know why that is being said. What we need to do, and one of the things we're trying to do at Flow is let's have a dialogue about the facts and let people decide what ought to be, rather than covering them up with this rhetoric, if you want to call it that. Some would call it spin, I guess. So water and air contamination. The water contamination is a result of the risk. You'll hear fracking has never caused a spill or contamination in the history of the United States oil and gas industry. It isn't the fracking technology, it's the casing that breaks, it's the joints that didn't work because they weren't cemented right or the pressures were so great. It's the spill, it's the accident, it's human error. The question is, with the smaller oil and gas wells that we've had traditionally, the risks were greater because there's less to take care of. And with this 5 and 10 acre massive deep fracking, it's more industrial, it's more intense, it's harder to take care of, i.e. the Deep Horizon well in the Gulf of Mexico. The other thing about it is, even though the risk of human error is there, the magnitude of harm is what with deep fracking?
Greater.
It's going to be greater. You're using huge quantities of chemicals and waters. And by the way, all those chemicals are left in the ground. Or flowback brings up 28% is the last number I heard of that chemical mixture comes up into a tank. So if it's 30 million, let's say 20 million, that'd be 30 times 2, so it's about 60 million gallons. No, excuse me. Help me out. 3 times 6 million gallons comes up as flowback. And they have to get that captured in a tank. They have to vent it, which sends fumes out. And there's a University of Colorado study at Denver campus that looked at some of the air contamination from fracking in Colorado, and it's exceeding VOC levels a half a mile away. VOC, volatile organics, which can be benzene and other carcinogenics. Okay? So it's something you have to be aware of, that these things are vented. Now, it could be captured, it could be recycled, and maybe those are things we have to talk about. It's not like, I'm not saying here fracking or no fracking. Communities have to make that judgment themselves. But there's certainly a lot more we should be doing before we frack. And I think that's why the Cannon Township moratorium was such an excellent move and example, and the one in West Bloomfield for the rest of the state. So wastewater, I just talked about that, but then they have to haul it off the site, the flow back, and it has to be put into an injection well somewhere in somebody's township. Okay? Transportation risk spills, about 2,000 truck trips per well. With everything involved. And if there's 5 wells on one pad, you're going to have 2 years of, expressway semi-traffic. They can only do 7,500 to 15,000 gallons if it's a double tanker, I guess. I'm not, I know it's roughly that. I guess they vary, but figure it out. 30 million gallons to be pumped out, 6 million to get rid of, right? Divided by 7,500 per truckload. A lot of truckloads, plus all the stuff that comes in, the equipment tear down, all that. Yeah, go ahead, but I'd like to do the Q&A at the end. But
do they drill the wells actually on site to get the water then?
yes and no. It depends on, I've seen both. If the water well, if the pad is too close to a lake or a stream so they're afraid that they might not pass the assessment tool, or if they don't pass it, the DNR says, well, we're going to let you do it, but put the water well over here. 1/4 mile over here, so they'll separate it with pipelines. And they're using more than one water well. Why? Because if they use one real big high-capacity well, it won't look good in the tool. They don't want to say, we're going to take, 5 million gallons per minute out of one high-capacity well. They'd rather have 5 of those at 1 million gallons per minute and do each well separately. They don't have to, there's not a way to add those all together. They do it a well at a time.
And the reason I asked that is in Ravenna, this fracking operation is going to be close to the village wells.
Well, that's something that you have to just dig in and make sure. You have to demand a hydrogeologic study. And I'll talk about this in just a minute when we get to that section. So what else what are the other risks? Roads, pipeline spills. Those are spills. Roads is noise and odor, right? Traffic safety and dust. And what? Wear and tear of your roads. Okay? Pipelines, risk of break, pits, tanks. What about the cleanup? If something's left, is it cleaned up right? What if the state doesn't have enough enforcement budget to get it cleaned up? Who does it? Can the township step in, do it, put a lien on the property, or a fine or a penalty, or is there a bond? These are the things you have to think about. So, okay. Well, now, for the next part of this, we're going to talk just about some legal things here. And for about 10 minutes, then we'll have a Q&A. I think I was supposed to do this in 45, but I did not. I apologize. Are you all okay with that? We'll do a little 15-minute piece here on the law, and then we'll stretch, and then we'll do a Q&A. Unless you're ready to stretch now.
No.
Okay. All right. So, real quick. Most of it is exempt at the federal level. The state, oil and gas is exempt from the water statute, but there's that supervisor letter saying, well, at least you have to go through the water assessment tool, but if they go through the tool and they don't pass the tool, they don't have to file an application with the Water Bureau. The supervisor of wells has jurisdiction to negotiate to put the well somewhere. One of the problems on state lands, and also you that might be leasing private lands for this kind of oil and gas development, is that there's a common law court case principle that the surface area and surface rights of your home, they are subordinate to the needs to extract the oil. So when you lease your land, there's an implied right for the company to do what they have to do in a reasonable way. They can't run over you without causing you waste anyway. They can do whatever they need to do to get the value of their lease because you signed that away. Now you'll see in the lease form that nothing has said anything about water. But the reality is water is a use connected to benefit the surface. And I think the answer in Michigan is going to be, if we aren't careful, that all the water needed for the development of the deep frac well goes first before you can use it on your property. It has a paramount priority to your own water use, unless you put a different clause in that lease. The state is not doing that. The state is not asking that question about how much water, and if they're not asking how much water, they ought to be putting something in the lease until we know how much water. This water doesn't pass with this lease. And every private individual should be doing the same thing. You can get this lease, but before you actually get the water, you're going to tell me where the wells are, where it's going, and you're going to show me through scientific studies that it isn't going to harm my water quantity and quality. That's how you deal with that. So this is really practical stuff in a way. I mean, it's nothing, it's just a new technology, a new threat that people have been dealing with in many ways, and particularly local governments. I mean, zoning, and you've got, you've had cell towers, you've had wind generators to deal with and regulate, landfills, Walmarts. It's just another land use that needs to be brought under wraps, like any sensible community would do, which is why we're here this evening. So, what do we do? Well, in your handout, handout, let's see, go to handout number, not number, there's one that says local regulation of horizontal fracking in oil and gas development facilities and activities. It's 2 sheets, 2 pages on either side of one sheet. Both sides of one sheet. Okay, so this is the basic structure. The first thing you'll see is under A. Is everybody there? Under A, 1, Michigan Constitution. Villages and cities and townships and counties have a right to insist on a franchise agreement for utilities or on anybody who wants to use the right-of-way or roads, pipelines, and trucks. Okay? You can ask for consent, and while you can't prohibit it entirely, you can ask for the information you need to make sure you have enough information for your fire department and your ER people, emergency people, and that you have enough information about what happens if there's a spill, you know what the chemicals are. You can add things like indemnity clauses if something goes wrong and the township gets stuck with the bill. You can sue them, you can ask for insurance policies or bonds. There's many things you can do to minimize the risk of roads and pipelines under your township authority. But basically under this constitutional provision, you don't need a state statute. And generally, the state is not supposed to interfere with that, right? So it's somewhat insulated. So at the very least, that's one power you have. Secondly, township, number 2, A2, township county police powers. There we go. The Township Ordinance Act, that's what started the townships, and it's what you exist under. Same with villages. There's a village statute. As some of you, I think I met somebody coming in here in a village here in Muskegon County. It says you can pass ordinances to protect the health, safety, and welfare. It also says the property and persons of your township in the Township Act. So you can regulate the activity and the harm, not the land use. Zoning regulates land uses. Police power ordinances regulate noise. It's like, like the dog off the leash, the nuisance kind of activity or the risk you're trying to prevent. All right? Fires in the backyard that are not regulated. But again, it could be anything like air contamination threats, groundwater threats, those kinds of things that might be a nuisance or create risk, particularly the chemical situation if there's a spill or an accident. And these you can require disclosure of what's happening, disclosure of the chemicals, accident prevention plans, okay, response plans, cleanup plans, the kind of things that you would insist on any business to do business in your community. All right. So what's next? The Zoning Enablement Act. If you called up Halfitch at the DEQ or somebody tomorrow and you said, I'm Ann Smith and I'm from Cannon Township. What's this township? Well, this is the city here. Right?
Muskegon Township.
Muskegon Township, right? I'm from Muskegon Township. And we're interested in determining what we can do with our zoning ordinance to get special use permits for some of the things related to fracking. They're going to say, you don't have any local, you'll say, well, a nice idea, but you don't have any power to zone at the local level. And most townships have been told this. So everybody thinks, we don't have any power. There's nothing we can do about oil and gas development in Michigan. First of all, I told you the Township Police Power Act, you can pass ordinances on risk and nuisance-like activities, right? Secondly, let me show you. All right. Under county and township zoning, this is not village and city. Village and city have no exemption for oil and gas industry. You can zone them. Okay, you can zone them, you can zone the location of the wells. If you don't want the wells in certain districts, tough luck for the oil, deep fracking. You don't have to put up with it. Now, you do have to have some strong basis for that. You can't just fly by night. You put together your study and your planner and findings of facts and all that. So oil and gas wells are exempt from zoning in townships and counties. So the supervisor of wells, or whoever you talked to, the DEQ, when you called Ann Smith, should have said, you can't zone the location of a well or regulate the drilling, completion, or production or operation of an oil and gas well. But you can regulate ancillary equipment, facility, and uses necessary for the oil and gas well. And that means water sources, pumps, treatment facilities, storage and disposal facilities, mixture tanks and operations, flow lines, gathering lines. A flow line is the first line that comes off the well to send the gas to the distribution line that the PS Public Service Commission regulates. And if there's two flow lines or more, that becomes a gathering line. And they all go to a gathering line, and the gathering line goes to the distribution line. You can regulate the flow in gathering lines. If the gathering line is partially PSC, you can still regulate it, not quite as much, but you can regulate the part that's not subject to PSC. So it's fair game. You see this little thing in the bottom here? Michigan Supreme Court decision in 1990, Addison Township versus Gout, says pipelines and ancillary activities and uses are subject to local zoning should the local township or county want to zone those facilities. Okay? That's the answer. I don't have to pretend. DEQ doesn't have to pretend. It's been decided by the Michigan Supreme Court. The oil and gas exemption in zoning does not apply to ancillary activities. And if we go back to that handout sheet, that little well pad, I've got, if you read that after tonight, you'll see all the words with the arrows to the pad. There's a lot of ancillary stuff there, okay, that you can be concerned about. Okay, so the next thing on our list, if we go back to that list, you've got home rule powers. If you're a charter township or become a charter township, your powers are a little broader because you have home rule powers. Go down to A6, the Michigan Constitution there, Article 4, Section 52. The air, water, and natural resources of the state are declared to be of paramount public concern. If you look at the constitutional debates, it says there's a public interest. That's very close to this idea of commons. And that Constitution says the legislature shall pass laws to protect the air, water, and natural resources for the benefit of the citizens of the state of Michigan. And the state passed the Michigan Environmental Protection Act. Let me go here if I can find that. I'm just jumping all over the place here. Yeah. We're almost there. Okay. The legislature shall protect them from pollution, impairment, and destruction. That's the air, water, and natural resources. This was implemented by the Michigan Environmental Protection Act in 1970. And if you look at the little handout here at A6, you'll see in the last line there, Vanderklut versus Highway Commission. Vanderklut versus Highway Commission says that the government has a duty to consider and determine the likely effects and the alternatives to those effects of any activity that could likely impact the environment, the air, water, and natural resources. That's an environmental impact assessment. Somebody had asked about that. The Michigan Environmental Protection Act, as interpreted by the Supreme Court in this Vanderklut case, says government has a duty to do an environmental assessment. It also means that townships and local governments can insist that oil, in their ordinance, can say to the oil and gas industry on this deep fracking stuff, these new things with this massive nature, we want an environmental assessment. Not for one well. The DEQ looks at one well at a time. They don't look at the cumulative impacts. So, you know, if it's going to cause the loss of one toenail per well, but if 100 wells will result in the loss of a whole foot, they don't look at the whole foot. That's the problem. Townships and local governments can do their own impact analysis requirement. So we want to know where the water wells are going to go. We want to know what the soils are, how much water there is. You give us this information so that we have it. And then we can consider the impacts and make a decision on whether or not this is lawful under the Michigan Constitution and the Environmental Protection Act. Okay, that's an umbrella way. You can actually stick it right into the standard of your police power ordinance or your special use permit on those ancillary activities. That's how you would do that. That's how we've done it in a number of, for a number of townships in other contexts. So, we go back down here and we'll finish up. Bans, there are ways to do it if you're a city or a village. It has to be done very artfully because you'll hear about New York and Colorado. Their home rule provisions and the way their laws are structured and the wording of the exemption for oil and gas, it's a little different. Every state is a little different. Okay? So you have to be really careful. I'm just here to report this. I don't have a position one way or another here tonight, but people often ask, well, can't we pass a ban? And you might be able to in a city or village. Townships, a little more difficult, although in some circumstances, if the resources at risk are so valuable and they outweigh, and the risk of harm outweighs the development, you could probably do so prospectively. That is, on lands that have not been permitted for oil and gas wells yet. No, you may be able to do so. I don't even want to say probably. But it takes a good planner lawyer. And so my point is, if you're going to ban, it isn't a simple answer. I don't want to say yes or no, but it's not a simple answer. Moratoriums, yes. Yes. Reasonable in time and scope, no problem. They can't sit there forever, because if you're going to do a moratorium, you better get working on your ordinance package and determine what it is you're going to do at some point in time, because that's why you would do a moratorium. Okay, I could go into I'm not going to go into that. I think too long. It might come up in a question. There's the moratorium. Finite period. Conduct a study of impacts during that period. Come up with a package of ordinances in the end before the moratorium expires. Active ordinances in Michigan. Moratorium here in I can do this. Hold on. Anyway, in Cannon Township, this is the weirdest mouse. So Cannon Township, moratorium. Filer Township, hydrogen sulfide and oil and gas ordinance. It's been there for 12 years, more than 12 years, 15 years. The oil industry decided not to contest it. Howell, that's a pipeline, pretty good one. Needs to be tightened up a little bit because of the fracking. This is before fracking. And you could actually expand that to pipeline and roads. Orangeville Township, roads. West Bloomfield Township, moratorium. These are some of the things that have been starting to move, some before, but West Bloomfield, Orangeville, and Cannon are all things that have happened in the last year or two. Okay? So there we are. I'm going to end there. I really appreciate you being so patient during the presentation. And thank you. Please join us at Flow. There's a card there if you care to join us or contact us or donate. We also have the Great Lakes Society, and we're looking for people that understand and want to be part of the big vision of a commons and public trust principle for the Great Lakes in this century to help us research and articulate that. We have a project and a proposal in front of the International Joint Commission about adopting this as a guiding principle for the Great Lakes Basin and all boundary waters in the United States. But we'd also like to move it into each state so it becomes the framework in which we look at these problems. We have the 20th century permits and regulations. They didn't quite work. We got a lot of things going on the planet. So the view is, our ideas, and this, we don't care what political persuasion anybody is. It doesn't matter. Our children are part of this. We don't know what political persuasion they have, right? It doesn't matter. But we want to make sure that there's a basic principle in place so that grandchildren and great-grandchildren of ours have the same body of water in the same basic shape that it is today. So thank you. I'll take some questions.
Yeah.
If we can. Yeah, did anybody want to stretch? Yes, sir.
Okay, good, thanks. I'm sorry that I didn't get here early enough to mingle, but I was just wondering if there were people here from Ravenna, and also I was, okay, we have one person from Ravenna? Okay, and then I was wondering if we had any City of Muskegon commissioners here or any county board members from the County of Muskegon here today? No.
They were invited.
I'm sure. How's
The
that?
city was there.
I
see.
noticed
Thank
you
you.
on camera, and it's fine. Would you see me after? Because we have a little
Sure.
release form
Good.
so that you're protected and we're protected.
Yeah, I'm not going to be making money off this video.
No, I know that.
Okay,
I
you
wouldn't
bet.
even
Yeah,
suggest
okay.
that. But
Right,
we
thank-
still have a release form so that there's no question.
Sure enough.
We allow it freely for education.
I see what you're saying.
Yeah,
Good,
just-
thanks.
Just make sure we're on the credit somewhere so
Good. You bet.
we get the word out. Yes,
In
I'll just go right around. if that's
In
okay.
Muskegon, we haven't, as far as I know, leased our public lands, and there has been great opposition to that, but it's been mostly the gas and oil looking at private lands. Are each of those ones that pass the ordinances of public lands, or are they public
thank
and
you.
private?
Good question. Generally, the legal authority in zoning is for private lands, but there was a case in the Michigan Supreme Court in 1998 called Burt Township. The DNR wanted to build a boat ramp on Burt Lake. The local folks zoned the boat ramp out. It went to the Michigan Supreme Court. The DNR said, we have exclusive jurisdiction over state lands. They can't be zoned. The Supreme Court said, there's nothing in your statute creating you, DNR or DEQ, that says that you have exclusive jurisdiction. This township has the right to zone the public facility. So there's probably some room to regulate the public. The other thing is the ancillary activities like pipelines and roads, for example, or the effects to air that you're trying to address, those transcend the boundaries. Pipelines go across both. So you're going to regulate it at some point anyway, right? It comes off the public land. It's got to go somewhere. So you find out where those points are. Okay, next, right around here, right here.
I just wanted to make sure if it was okay if I make copies of these, because I did talk to a couple townships today that couldn't make it, but did want the information.
You may make copies of those.
Okay.
Oh, absolutely.
Okay, thank you.
Yeah, that's what they're for your community. Right here, then I'll go over here. Yes, sir.
Local communities require the drilling companies to pay for additional personnel, training, and equipment for the local fire departments and other
Yeah.
emergency responders to deal with hydrogen sulfide.
I mean, that has to come from tax revenues or the state or, there's not very good tax sharing from oil and gas development, as you know, at the local level, right? I mean, it's been a few years since I looked into that, but, back in the Antrim Shale, the local governments didn't get much in exchange, for that. But what you can do is this. There's a statute, as you may know, that if a township sets up an ordinance system, they may charge the necessary fees to have experts to review that permit if it's complicated and involves facts that, the township officials wouldn't ordinarily be expected to or would they want to provide an opinion on it? So there's ways to pay for the administrative cost of the ordinance up front in the application process, which the Filer Township did. And in Filer Township, I forget what the bill was, but it was so complicated because of some of these oil and gas release accident issues with air modeling and dispersion, air modeling in the dispersion zone of hydrogen sulfide, for example. I mean, the costs were, over $10,000, and the companies readily paid it. They had to in order to get the answer that they had to establish to get the approval for that particular pipeline. But unfortunately, I don't think you can say, here's a permit, but pay for this, this, and that.
How about an early warning system in case of a hydrogen sulfide?
Well, yeah, if it was a requirement of the ordinance and there was a factual basis to need it, that would be something different. That's a very good thought. I haven't heard that before, because the state warning system sometimes it goes to it's an electronic warning, and it goes to a phone that's supposed to be set up with somebody there. And there's a lot of times nobody's there. I mean, they check it, but if it's hydrogen sulfide, you'd want somebody there like that. Okay, questions over here. Right here. Oh, right here. Okay.
We have county roads and we have township roads.
Yes.
We cannot do anything with the county roads, the township
Right.
can't. We can do our township roads, but
Right.
we can't do anything with county roads. And Harrisburg Road is a county road.
Okay. Well, the county would have to do that. So the townships should get together and say, look, we're concerned about this. You've got the same authority we do under the Constitution. We'd like you to do this. The road.
Have you
the
tried to
road
work with
use and the
Muskegon
pipeline.
County?
Pardon?
Have you tried to work with Muskegon County?
I have not worked with Muskegon County.
Yeah, they don't
I know
like to
road
work.
commissions are tough to work with because I have worked with. I have represented clients against road commissions.
Would it go to
They're not very.
the county commission, or would it go to the road commission? I mean, could you approach the county commissioners?
That's a good question. I mean, it probably depends on the agreement between them. I mean, road commissions are separate bodies and do have jurisdiction.
They're elected.
But the Constitution doesn't say road commission. So the interesting question that I would have is, even if it is county, if the township has the authority to get are you deprived of your right to a franchise with these risks? Just because it's a county road? I'm not sure you are. Now, I'm not, I don't know the answer to that. That's a good, that's really excellent.
This is
I'm
what
gonna
I
go
have
back.
come up
We're gonna find that out. And I'll let you know. I can send it to Cynthia, or you can leave me a note or a card. Well, that's a good question.
And another, this hazmat, Muskegon and Newaygo. Moreland doesn't have a hazmat team.
Okay.
Ravenna doesn't have a hazmat team. You have two hazmats.
Well,
That's
that's
Newaygo,
related to your question.
and that's Muskegon. That's why I wanted to say this, because this has been brought up also. Because if it comes into Moreland Township, I want to know the chemicals. I want to know the reaction that they have to look for.
Yes.
But
Yeah. And I think you can do that. The only issue we didn't get into when we do the programs with the township, we go into great detail in the second and third sessions. And then it goes to the planning commission, then you get your attorneys involved, and you work through the steps. But trade secrets, you cannot ask for the formula. The state requires material safety data sheets under the Right to Know Act. Not all chemicals are covered by the Right to Know Act, as some of you may know. And they're not filed until after the thing is built and completed.
yeah, well,
So-
that radioactive isotopes.
Exactly.
When that turns into
That's outside the
a
right to know.
scale form, that is where it's most lethal.
Yeah.
Well, the state
You
doesn't.
have to,
The state doesn't verify that list is accurate anyway.
Pardon?
The state doesn't verify that list is accurate anyway.
it's just material safety data sheets. There's
That's all.
no
It's just a paper.
verification at all.
Emotionally,
So,
it's possible.
but when the company does that, they're verifying that it's accurate. So there are some real problems of liability if they don't do that correctly, and somebody is injured by a chemical that's not on that list. That's where the companies are going to get in trouble. I don't think the fact they have a trade secret doesn't insulate them from liability. Let's just, to get to your question, one more piece of this. I think you can ask for disclosure of the chemicals before they come into your township, because you've got to know what they are to be responsible.
And that's what I thought.
And your emergency people have absolutely got to know.
Even though we don't have
Yes,
a...
yeah, and we think the Environmental Protection Act...
Township works with each other.
Right, and we think the zoning special use permit would do that, township ordinance, or the Environmental Protection Act assessment. You can ask for anything related to health, safety, welfare, pollution, air, water, and natural resources that is material to the standards that you're trying to uphold. Question?
Since this fracking is coming to Swanson's property, which is in Ravenna Township, but the township, they seem to be all for it, Ravenna Township. You won't see anybody here from Ravenna Township, because I believe that the officials for the township they want it. You know, they think it's a great thing. So they're not going to even try to get any type of moratorium. What happens, how can that just set with them? They can have that authority to make that decision.
Because the people is...
Well,
I mean, is there any...
it's the political democratic process in the United States. If it's a legislative decision, the only way you change it is to elect somebody else and put them in the legislature at whatever level of government. Now, that said, it's a matter of education. So you find one township member, one council member that's willing to listen. I mean, look, you don't have to be pro or for. Facts are the best advocate. Good information is our true advocate, one way or another. All right? If it's extreme one way, then that's not fair. If it's extreme the other, what you want to do is keep developing the information, telling the information in it, and people go, oh, wow, that's what you're saying is common sense. We ought to do something. And you do education, and you have somebody like Flowcom or somebody else that does educational seminars on the basics, and try to start a dialogue and a discussion, even if it's one meeting that they're willing to do without any commitments. Right? I mean, farmers and landowners have a right to lease for oil and gas.
Right.
But like everybody else, there's still the question of the power and the right for regulation. You want to do these things right because it's a whole community. Right?
Right.
So you have to have that kind of discussion. Can we do this in a reasonable, sensible way or not? Now, if not, then you have to go to your current zoning ordinance and your book of ordinances and see whether parts of the fracking, the things, these different pieces, roads and pipelines, are they structures? Are they a building? Are they an industrial use in a residential area? In the Nestle case, Nestle had to rezone the property to get their high-capacity wells in there. Rezoning in townships is subject to referendum. So you find something that is regulated without any new ordinance, and you insist that it apply. If they don't apply it, you would have to file a lawsuit to force it. But once they had to do it, if the judge agreed, then they make a decision, and if you don't like the decision, then you ask for a referendum, because you do have the right of a referendum under the Zoning Act.
And spot zoning is illegal, right?
Pardon?
A township cannot spot zone. You know.
Well, that's like begging the question. It depends on what the courts consider to be spot zoning, and they're all over the place. But what they can't do, what they can't do is say this is a residential district and permit, a high-capacity water well for an industrial purpose next to your house in a residential district. How are they going to do that without rezoning? And if they rezone for that, you ask for the referendum to get rid of the spot zoning problem. Or you argue that it's spot zoning. But the real question about spot zoning is, did we contemplate having a high-capacity industrial well in a residential district in our master plan? And if we didn't, then it shouldn't be allowed.
And some townships don't know their master plan has to be redone every 5 years.
And the neat thing about that is, the way this works is, if you get a high capacity, if you stop a high capacity well, the only way they're gonna do it is to get a special use provision. So now they gotta come back and actually do some zoning to figure out where these are gonna go and under what conditions. So it's give and take. I mean, that's, you know, that's the love of being in our country. Or that, what do they call that?
Yeah.
Love, hate.
Money talks.
I forget the name of that word. Cynthia.
Another thing that she brought up that had occurred to me earlier, do you know very much about community right to know on the local emergency planning commissions?
I used to know a fair amount about that about 20 years ago, and I have to confess that there's been so much.
But,
But Cynthia, go ahead, discuss that.
So I just, basically what I was wondering is, does that community right to know, you know, would there need to be an emergency plan if it's a single use or 3 uses of that volume of chemicals? And, you know, if so, is that something, because I know that the LAPC in
I think under the state act, you might, I think the feds exempt, I think that was one of the acts that's got, you know, chopped along with the other things.
Yeah, that's possible.
Yeah, not the material safety data sheet part, but I mean, let's find out. That's another good question.
Yeah.
That's really good. That's an
Because the
important way
LAPC
to
was
get
always
at it.
very independent.
So let's see, a couple more questions.
Got one here.
Okay, I'm going to finish over here first, and then I'm going to come back.
He's probably more ready than me.
Yes, sir.
You probably heard this a million times, and I talked to Senator Hansen, and the first thing that came out of his mouth after I explained fracking a little bit, well, what are we going to do about the energy? I mean,
Yeah, I know.
well, I just want your opinion, because I mean, I had a few things I told him, but as long as you're here, I'd like to hear what you have to say.
Well, it's multi-layered. I'll try to do it quick. First of all, energy is one part of our society and one part of our economy. And there's lots of ways to produce it, and there's lots of ways to conserve it. Right? And secondly, natural gas may or may not be the transition fuel we think it is. Because the market price of natural gas is low right now. Okay? So there's no money being made. The money from fracking is coming off the oil from North Dakota, which does 10% of our oil production now, and it's going up and up, and elsewhere. But the talk is the president or the new DEQ chief just approved a liquid natural gas plant in Texas, right, for a company so they can export around the ban to our trade partners. Under the trade laws, you can't export natural gas. If the country hasn't signed the trade law, we can export it. If somebody gets permission to build the plant and do it. And the administration just approved one, presumably for China and Japan. If that happens on a mass scale, now these things take billions of dollars, they take a long time, it's high risk, and maybe 5 years from now, the price of natural gas goes up to 5 or 6. Okay, if that happens, that's only going to push us to renewable energy quicker, because the price of renewables, solar, being made more available to homes, conservation, and wind, and I know that's debatable. Wind we have in the wrong structure. It should be more community cooperative, different scale than these massive, owned by distant companies. But if we get all that right, the price of wind is coming down so fast that it's competitive with natural gas, if not more so. There's a Lloyd's of London report that I only looked at cursorily, but was described to me by an energy expert as critical for understanding the finances of energy in the next 15 to 20 years. But Lloyd's of London thinks that fossil fuels are just a bad risk 10 years from now.
Sure.
So you have the financial question, You have the fact that all forms of energy still have to be regulated. Yeah. Dear Senator, I want energy too. I might even live with fracking, but does that mean they get a free lunch? Because certainly the other things don't. And I think the country is running so fast under the umbrella of this fossil fuel thing to save us right now that we're missing the reality that there's a new economy there based on a completely different mix that can lead us into the century and our children, and we'll have the most vibrant economy like we've had in the past. And the countries that do that are the ones that are going to have the money and the vitality. And the ones that don't, we're going to get stuck. So, yes, like I say, I personally would never say, some of you may not like this, but I would never say never that there couldn't be any fracking anywhere in Michigan, because there might be a situation where it could be allowed under certain circumstances. I don't know the answer. There might not. And then I'd say, no, you can't do it. But I think we have to be open-minded enough to move through this time period, because most likely, the other thing is these deep fracking wells, based on I don't want to say, I don't know the Department of Energy, I don't know the study, but I will, if you want to see it, I'll get it for you. The studies are saying that the life of the fracking wells are not 10 and 20 and 30 years like everybody thought, like the other oil and gas wells. These deep these deep gas wells are looking more like 6 to 7 years. So it may not pan out to be everything, the answer that the senator thinks. So all you can do is, hopefully the senator gets more informed. I mean, yes, energy, there are some important justifications right now for doing some of this to keep our economy going until we make the transition. I would also say, if we do fracking, and there is a transition, that we must have a carbon tax or a methane tax or something where the money goes into a trust fund and it cannot be touched, and it benefits the whole society, the state of Michigan, all right, in the future, so that we can make the transition that they're telling us they need the natural gas for. We need the natural gas, it's our transition fuel, then let's guarantee it. So, yes?
Okay, so many things, but one is, are we not being betrayed by our public elected officials, because are they not supposed to, like the DEQ, aren't they supposed to be stewards of our land, and they are supposed to protect the value of our land? I mean, once you've fracked a piece of land, you've destroyed it, right, forever and ever and ever, and everything around it, and you don't have pure Michigan and all that anymore. Okay, that's just one thing I wanted to throw out there. But the other thing is, I really appreciate how you keep saying, let's just stay with the facts, and maybe there are places that we can frack that would be okay and all that. But I guess what I come to every single time is, we have a finite amount of water on the planet. Can we really afford to destroy any of it?
Yeah, good point. I think if you apply the regulations in a way where the burden of the lack of information to make a meaningful decision based upon facts, the companies will have to go forward with hydrogeologic studies and do the pump test for 5 days. Here's what happens is, you put in monitoring wells around in the lakes and streams, the wetlands, and you have a monitoring well system. You're recording the effects of the pumping. So you put the system in ahead of time in the right place, all right? Flows and levels of all these
That's
features.
all you're doing. You're not drilling yet.
No. This is what you do before you ever get a permit.
Okay.
And then there's a pump test when that system's in, and the pump test is done at 150% of the volume that they intend to use, or 125%. And all these little monitors are measuring literally what's going to happen when they do it. It'll show up.
Okay.
So if there's going to be harm to volume of water, it'll show up. If there's not, it won't show up on that monitoring system. Now, the system has to be done right. And I've seen systems done in ways to evade the truth, but they have to be done right, so you need an expert.
So we don't want the DEQ.
But what we need to do,
Yeah, right.
I think my answer is to your bigger question, is that if we don't know the facts, we shouldn't do it.
Right.
The obligation to the future is that we don't make decisions that foreclose the future and destroy and lose the water on the planet. Period. We must have the information. I don't care if it's fracking. The principle we're applying in the fracking is the public trust principle. I didn't get into the public trust program, but under the public trust principle, the burden of proof is on the person seeking to use the public trust resource. They can't use it until they demonstrate no effect.
So how do we enforce that?
Well, you get it. It's called deep education. We have a lot of thinking and educating to do, and then you get it as a legal principle, which it already is, and you enforce it by lawsuits. We have a three-part government. You know, we have the executive branch, the legislative branch, and the judiciary, and they're a check and balance. Remember, we learned that in high school government class, and there's a lot of truth to that. It's darn good that we have it. And yes, lawsuits are expensive, but I can tell you the lawyers you hire work their butt off. I mean, I'll speak up for the lawyer profession. The stress and the work, they earn it. And if they're overbilling, you do something about that. But basically, it's tough stuff. So, but sometimes necessary, or you just, it's like if you can't uphold it when you have to, then what good is it? So. Okay, two more questions and then we'll call it off. Okay, 3, and we're done. Yes.
Do you have any DVD or notes for a presentation to educate about, with the truth, especially about the different myths that are put out on both sides about fracking, so that,
we
people...
want to do that, we just don't have a budget.
Just a note, we actually did do that for the DEQ meeting. Karen, Dale Wilson, and I who left.
Yeah. Oh, yeah.
We actually created a really nice sheet. It's nice. I
What
mean,
DVD?
it refutes the DEQ site. I mean, those are the only myths that it refutes, but those are the common ones.
And look at your fact sheet.
So I can get that to you, Shanti.
This fact sheet, did you see this?
Yeah.
Yeah, look at all those. Those are some of the basics.
And there's a huge, really long one that Let's Ban Fracking did as well, which all Karen and I did was condense that.
That's so important. Education is so important. Is there anybody here from the media, like from the press? Is there M Live here? Anybody here from?
They were at Cannon Township this morning.
Oh, they were?
Yeah.
M Live? Yeah.
So,
Yeah, M Live was it.
what was I going to say? Oh, Paul Brady in Kalkaska is doing a terrific job, right, Cynthia? I mean, you've seen his webpage.
I haven't.
Oh, he and his buddy Matt, they are creating an informational, interactive webpage.
What's it
for
under?
information fracking. I've got it written down. But Paul Brady, Google Paul Brady Kalkaska, and it all comes up. Or Paul Brady fracking. And then Jackie Rose, Jacqueline, yeah, she's got some a really good PowerPoint on the
Let's
facts.
Ban
Detailed
Fracking
PowerPoint on the
site
facts.
has.
It's good stuff.
What kind of surety bonds are required by the companies? Because we have a legacy of orphaned wells from the 60s and 70s that nobody seems to know how to even cap, much less
Yeah, the state
take
bonds
care
are
of.
not enough. The DEQ bond level is, it's like $25,000 or something like that. It's not very much.
Or you can get a blanket bond for $250,000.
Yeah.
Which gives you up to 10 to 12 wells.
You can do that? Yes, right, exactly. Yeah. So the town, again, that's something you might look at, the kind of thing you might look at to cover certain risks should they occur. Okay, right here.
Mr. Swanson has high-capacity irrigation plus the fracking, is this is he kind of defeating his own purpose here by?
I don't know who he is, and I don't want to say, but I said earlier that, high-capacity water withdrawals at the same time
And that 30
can
million
cause
gallons that you're talking about,
conflicts.
that's waste, right? It's gone, right?
The fracking is gone.
That fluid is gone, right?
That's gone.
Yeah.
It's out of the water cycle. You understand? It's out of the area where you took it from. When it goes down in the deep formation, it's pretty much there. Now, there are some people that argue that it could move over time, hundreds of years. There's a Cornell study that says it could move upwards. And the deep injection well. So it's out of the water cycle, presumably, we hope, because it's contaminated. It's all contaminated.
Also, there's a trout stream near this well.
It's a matter of hydrogeology. They have to if there are wells, they have to get them from the health department. You go to the health department, say, I'd like, freedom of information. Let me see the well permits this month or for that property, and they have to give them to you. And you find out how much they're drawing and what the soil type is, and then you have to see a hydrogeologist or a geologist and make sense or get the books out. I mean, it's pretty basic, You got water flowing underneath the ground, making lakes and streams, and at some point you take out more than comes in. It's like spending too much money in your bank account. Only I don't like to think of water as just a bank account. Okay. Thank you. We can talk after.
I've got petitions here for statewide ballot for anybody who hasn't signed one.
Oh, and
Karen already sent them around, but she hasn't.
but I have some that people can take.
Good.
Oh, good.
We need a few
Yeah,
more.
But is yours Ottawa County?
You
Well,
write the
just
county
write
on
it
the
down.
top. So I wish I'd brought more, but I got plenty for each of you to take at least 2 or 3
Good.
sheets. And then you can get more.